Welcome everyone. Welcome everyone to our next meeting of CSBARS, and I believe the last one for this year, and the last one potentially for a couple of us that are on the committee. But everyone will be invited back, regardless of the outcome, next time for the goodbyes, because we're not sure who will be appointed and how that will go forward. So there's a separate issue we'll discuss later on that one at the next meeting. With that, we can. I just want to identify specifically before we do our public comment, just to be mindful of our time. Last time I was very grateful everyone volunteered additional time on top of the time they already volunteer as part of the CSBARS. So I want to be mindful if we can complete everything within our allotted time. This time we have two challenges to that, in that we have two special set items for individuals that will be joining us. So we'll have one at 1:30 and then another one at 2:15 in between our start time now and our end time of 3. So we also want to be very mindful, watch the clock. We'll make sure to flag as we go through. With that, now's our opportunity for public comment. So if there's any members of the public wishing to make public comment, please express that interest by raising your hand electronically on your computer or pressing *9 to raise or lower your hand if you're on the telephone. You'll be recognized in the order that you raise your hand, and each will be offered up a period of up to 2 minutes. Again, further public comment can always be emailed to Ms. Leonard, whose address is on our agenda. So that's always an option before or even during or after this meeting. So with that, do we have any public comment?
Mr. Chair, I do not see any public comment. I do see the arrival of Mr. Murphy to the CSBARS membership, and I do believe we are ready to call roll.
Excellent, thank you. So next we'll call roll. Robert, if you could call roll for us.
Of course. Jay Frickberg.
Present.
Michael Clancy.
Present.
Linda Keller.
Present.
Greg Murphy.
Present.
Jessica Park.
Present.
George Leal.
Present.
We have quorum.
You forgot me, apparently. Paul Kramer.
And Paul Kramer. Thank you.
And Jim. Yeah.
Thank you. And again, for accuracy of our records, our next issue is our approval of minutes. Our minutes were posted prior. Does anyone on our committee need additional time to review if you have not already viewed our prior meeting minutes from June? Not hearing any. Is there any motion to adopt as is, or a discussion to correct any potential issues within the minutes as proposed?
Also move. I'll second it.
Okay, moved and seconded. Robert, can you do a roll call vote, please?
Of course. Jay Frickberg.
Aye.
Paul Kramer.
Aye.
Michael Clancy.
Aye.
Linda Keller.
Aye.
Greg Murphy.
Aye.
Jessica Park.
Aye.
And George Leal.
Aye.
The motion carries.
So now we move into, I think, the most interesting area of our discussions always are staff reports. So our first report is from Ms. Nunez. Is she with us? I'm not sure if I saw her.
She is not. So I am standing in for Amy to do this provisional licensed lawyer result report. So Robert, could you share those slides again for me? Perfect. So as Amy has been doing in the past, coming to this meeting just to give a little recap on the provisional licensure program to date. Next slide. So as you can see, between the original program that was for 2020 graduates and the expanded program, right now we have 300 active provisionally licensed lawyers. 1,166 provisionally licensed lawyers are now licensed lawyers as they've been admitted to the bar. 629 of those in the original program passed the bar exam, and another 537 work the 300 hours, receive positive evaluations, and all the other requirements to be admitted in that program. The remaining cohort includes 15 suspended applicants and 104 terminations. Suspensions can result from not having satisfied the moral character requirement, and then maybe that applicant is now appealing that determination, for example. Terminations can result when you don't meet the all of the rule requirements. One of the requirements being completing the new attorney training program. We did actually extend that date a couple times, but if they have now not met the extended deadline for new attorney training, they would have been terminated. Altogether, 1,585 applicants participated in this program as of this week. Next slide, please. So just looking at the race and ethnicity of provisionally licensed lawyers that have been admitted, you can see that the group that identifies as white is the largest of the population, 42.8%, followed by the group that identifies as Asian, 18.8%. You can see obviously on the slide sort of how the rest of the breakdown goes there. So a school type from provisionally licensed lawyers who have already been licensed, the California ABA schools, that's 36%, the majority there, followed by Cal Accredited. I actually was sort of trying to track this in comparison to our general statistics that are posted after the bar exams. I was looking at that earlier today to see how that sort of tracks, given those statistics are about who passed the bar exam and may not exactly be lined up with who got licensed after that. But this does have a larger percentage of Cal accredited schools becoming licensed, and usually with the bar exam pass rates, it might be the California ABA and then the out-of-state ABA in terms of percentages. But this is just a really rough estimation I was doing earlier today in case I got the question, but it's not exactly apples to apples. And then you can see the rest of the breakdown there. Finally, looking just by gender, how these provisionally licensed lawyers who are now licensed lawyers identify, 55% of them identify as female, and then you can see the rest of the breakdown. And that's the slides on our update for today.
Thank you. Any questions from our committee members?
Well, not a question, but a comment. I'm pleased to see the numbers. It certainly was a great idea that clearly worked to the benefit, even in a small way, to further diversify the bar and give otherwise very worthy applicants an opportunity, despite all the challenges that they've had over the last couple of years. So to everybody at the bar and at the court, you know, I think a lot of thanks and gratitude is owed.
No, definitely. Dean Park, you have your hand up.
Yes, I just had a question about the other category, I think was on one of the slides. For
Yes.
the category of schools. Just
The
curious.
other category of law school, was that the one? Yeah. So those could be law schools that are no longer accredited, that are no longer fit between any of the categories. Those could be folks from well, there was one category for foreign. So there's just, then that appears on our general statistics too. So it could be law office study. It could be a variety of different things that kind of go into that other bucket in our statistics.
Okay, thank you.
So hearing and seeing no other hands from our committee members, Ms. Ching, definitely thank you. Doubly thank you for jumping in as well. As we
No
go
worries.
Our next staff presentation is a report on the opportunity to schedule presentations on lawyer assistance program resources for law students.
Yes, and so to deliver that, we'd like to welcome Lita Abella from the Lawyer Assistance Program, and she will be appearing in just a moment to provide that update.
Thank you.
Hello. Thank you for allowing me to spend a few minutes just to give you some valuable information. I conduct outreach for the Lawyer Assistance Program, and I just want to give you a brief overview of the services that I can provide to your law students and bar applicants, and also to your attorneys that are alumni of your schools. I conduct presentations that deal with substance use and mental health issues and how these issues can impair an attorney's ability to provide legal services competently. I discuss wellness strategies and the resources that are available to your law students and bar applicants, such as our short-term counseling program and our personal counseling program that deals with relationship challenges, burnout, grief, and other issues, stress, and so forth. We also have our long-term counseling program, where the participant would meet with our licensed clinical rehabilitation coordinators. They would come up with a treatment recovery plan for the participant, find weekly group support sessions that they can attend online, because it used to be in person, but since the pandemic, everything's being conducted online. They'd also find a therapist or counselor that deals with their specific issues, whether it's depression, anxiety, bipolar, eating disorders, whatever the issues. And so I conduct these presentations at various law schools during orientation week for your 1Ls. It could be during mental health week for any of your students. It could be during bar prep for your 3Ls, your 4Ls. It could be during professional responsibility classes, 30 minutes, 45 minutes, whatever is convenient for your professors and your law students and their schedules. I also conduct the same type of presentation for a 1-hour free MCLE for attorneys, in which they get their competency specialty credit. So if you have an alumni association that meets at your school quarterly, monthly, whatever, I'm available to conduct those presentations. I have handouts that I've provided to the admissions staff that they can provide to you with the contact information to our office. We also have this information on the State Bar website under the Lawyers Assistance Program. I also send out emails to all the law students and bar applicants, which I believe there's over 25,000. I send that out twice a year to let them know about the resources. I also send this information out quarterly via admissions to all the deans and registrars and law school administrators to let them know that this resource is available for you. So I hope that you utilize the resource. Comments that I get from a lot of the law students once they hear the presentation is, oh my gosh, I wish I knew about this. I'm a 3L now, getting ready to take the bar, and I've been struggling with some of these issues, and I wish I knew about these resources. And even more so, with the comments that I get from attorneys are, I've been practicing 10 years, 15 years, 20 years. I've never heard of the LAP program. You really need to start with this in the law school so that students know that there's these resources out there, because we all know that being an attorney, being a legal professional is a stressful job. And if we know that there's resources there, we can help prevent, be more proactive in prevention. So I'd be happy to answer any questions that you may have at this time. Okay, well, thank you so much for allowing me this brief opportunity to share some information with you. Thank you.
Ms. Leonard has her hand up.
I did while we're together. I'd be interested to know how many of the members here are utilizing the program. Have you brought a program to your school? Or are there things you can think of that would encourage the usage? From time to time, we hear about students who are worried to access the program because they fear it will affect their ability to license, which is not the case. It is private and separate, and even in a separate building. So what could help us to engage with each of your schools in particular and help to allay that fear of students in general?
Dean Park.
I just wanted to mention, I'm very appreciative of how the Lawyers Assistance Program has been contacting the administrators and promoting its services. I think it's so crucial, especially at this time, that students are aware there are resources for them. And I think from a prior law school assembly, when a presentation was given, I was able to share that with staff And we have an online student center for our law students where we can dedicate part of a module to resources that we're aware of externally to the law school. And so for us, it was really a matter of dedicating a portion of our student center that we typically have for state bar information, but including this is part of what the state bar offers. And I think especially telling students it's available to them, but making them realize it's not just with their enrollment and it's something that could be available afterwards was very, I think a lot of people welcomed hearing that message, because so often people hear about a program or service, but think, oh, it's possibly not for me, or it's going to take a lot of work to figure out whether it is for me. So having that information descriptively upfront is helpful.
And
And
Dean- oh,
I
sorry.
did have a question, but happy to cover that.
No,
later.
please go ahead.
I was just curious, from your perspective, even if you were looking at, the last 12 months, is there something that comes across as especially in demand out of the resources and services that you offer? Is there a particular one or, top three that people are contacting you and asking for the most?
Are you referring to whether it's short-term counseling versus long-term counseling? No, I believe we have about the same amount of participants in short-term counseling and long-term counseling, which is so underutilized. It's unbelievable how underutilized it is. But no, I don't have any statistics on like what's the top as far as like if it's a stress concern or a depression concern. I personally don't have that type of information because I'm just the outreach person, and so our information's highly confidential that I don't know what people's issues are. So and that's not really public information.
Okay, just wanted to check.
Dean Leal.
Yes, thank you. Ms. Abella, I would think it'd be more time and even cost effective if you in your office had a webinar, and maybe you've done this in the past, and if you had an agenda that would, and have some panelists that would discuss, the very worthy and needed services that your office that LAP provides. I would be very happy to disseminate it in my enrollment. And if there's a specific date and it's an hour-long webinar, I think there'd be a few that would be interested in attending. So I don't know if you've done that in the past, but I would ask, or at least encourage you and others at LAP to put something together and make it available by way of a Zoom webinar, because that's clearly the easiest way to reach the largest number of interested individuals. And the other point is, because this is, if there's one element among my enrollment that I think affects their performance at all levels, both in school classes and then on the exams, is stress and anxiety tied to, just time management and work-life balance. And, I've got a number of law enforcement officers who, with mandatory overtime, work pretty hard and are putting in 45, 50-hour weeks and still manage to keep up with their studies, but it takes a toll, and I've lost students exactly for that reason. Kind of a preventative idea, offering advice to how can very busy, law enforcement, entrepreneurs, self-employed, or folks that just have demanding bosses can manage to deal with that and still come to class prepared. So just from my anecdotal experience, that seems to be the greatest stressor that affects the performance of the folks that we're trying to teach.
You hit the nail on the head. So let me go back to the first comment about the webinar. We have had what we've been calling State Bar Day, in which we've had presenters from Lawyers Assistance Program, Office of Admissions, Office of Chief Child Counsel, Attorney Regulation and Consumer Resources, and some other offices in which we did conduct a webinar. And I had over 900 people register for that. And I believe we've had several of them. We've had attendance of 500, 600, 700 that participated in that. And that also was emailed out to all the deans and registrars and everyone in social media. It was on social media, advertised and so forth. So we have been doing that. We've been trying to get that going about every quarter because it's a huge production that we did. As far as the work-life balance, it's so funny that you mentioned that, because that's the actual topic that I've been presenting for this year because of everything that's been going on. My background actually is in law enforcement. I was 20 years LAPD. So I know the stressors and going to law school, you know, while you're on the job and so forth. I know it's very stressful, and that's something that I talked about in my presentation. How do we have that work-life balance? What are the solutions to that? What are the symptoms? What is it that we know that we're getting ready to hit that burnout point? So these are all the discussions and topics that we talk about. My presentations are interactive, so we get feedback, we learn from each other. It's very interesting and very valuable information.
Thank you for that comment. And I do remember, and I know that's what triggered my question of having some memory. You've done that. But was it though part of a larger bar presentation where there were, you know, a number of other offices where other programs were being, you know, discussed and offered to the public, or is it just all about LAP, the prior webinars?
The prior webinars were with other offices, but I can, if I can do something where I can have a webinar where it's just LAP and see how that turns out if we get a good number of attendees.
Well, I would, you know, ask that maybe that you explore that, because again, if I'm able to, and other deans and schools can say to their students, you know, from 1 to 2 on this particular day, this is what exactly is going to be discussed, as opposed to a, you know, a lengthier, maybe even day-long program that covers a lot of matters and issues that would be of little or no interest to the students. But what LAP offers and the services that it offers, I think would be, so it just would call it out and emphasize the direct benefit to the students that, you know, you're trying to reach.
Okay, that's a great suggestion, and I'll talk it over with our people and see if we can come up with something like that. Thank you. Any other questions, comments, concerns?
Doesn't appear to be. Thank you, Ms. Abella. I think it's a great topic, and especially for our group, the accredited schools, the registered schools. You know, many of our students are sometimes first-generation Americans, most often first-generation professionals, and they have no frame of reference at all. And I think, as Ms. Leonard brought up very appropriately, there's a fear, that they already believe the imposter syndrome. Maybe I don't belong, and they don't want to be too open, either with their professors or the administration of their schools, or with the bar as it relates with the moral character application. If I divulge this here, is that going to be known over there? So I think that conversation is an excellent one, to put them on notice. It is okay to ask for help. We should ask for help, and that's the only way we will get help is if we actually do that. So thank you.
Thank you for inviting me. Take care.
Now, Ms. Leonard, we have a special set at 1:30. Do you think we have enough time to do our next topic, or you're muted currently?
We do. It should be brief if you don't mind.
Absolutely.
Okay, terrific. So I want to take a moment to remind our schools here who are members, and also those out in the audience or who may watch the webinar, about how to make public comment when there is a rule proposal. And there is a current rule proposal that the Board of Trustees posted recently. It's related to the ability to swear in once a student once a potential licensee has appeared on the motion. So just a second, and I will share my screen. If you go to the State Bar website and type public comment in the search box, you will come to our landing page for public comment as to rules. And currently, I'm going to take you to the specific rule about the elimination of the time limit on the validity of a passing examination score. The Board of Trustees posted this recently for public comment, and public comment is being accepted through September 12th, 2022. This was mentioned at the CBE meeting and announced at the Board of Trustees, but we want to make sure that everyone does get this information. Right now, an applicant needs to swear in within 5 years of the date of the bar exam that they passed. This rule would change that such that once they have the passing score, that time limit requirement would be lifted. This does also change somewhat the moral character determination expiration period. And if you read the underlying material that you can find in this link, there is a comparison between attorneys who go inactive for a long period of time as well as those who take a long time to swear in. A reason why someone might take a long period of time is because they've moved away or they take another sort of job for a period of time when they don't need an active license and later on they do. So you can learn about the background here. You can see the full text of the rule proposal. And then moving down, you'll see an online public comment form, and you can click there and make a public comment of any length, including adding attachments. So I just wanted to bring that to everyone's attention. And then if there aren't any questions, I have a couple of quick announcements as well. Okay. So a couple of quick announcements. First one regarding e-oath cards. I know that you heard about that a couple of meetings ago, and the e-oath card process is going very well. As a reminder, if you do group admission ceremonies when your graduates are being admitted to the bar, please be sure to send to the bar individual PDFs or mail paper copies of the oath cards. That will speed their processing. But also thank you. Your adherence to the new DocuSign program has also speeded their processing. So that's very good news. For those of you who have applied to be members of CSBARS in the future, thank you for these applications. We wanted to give you an update on the overall time period. The new members will be selected by the chair and vice chair of the Committee of Bar Examiners for the new year once they are named. They have not yet been named. So for those of you who have applied, please rest assured that your applications are under active consideration and they'll be presented to those officers as soon as they are named. And then finally, regarding testing accommodations, I just want to remind people that recently we had a testing accommodations stakeholder input forum conducted on June 29th. We did that to seek input on changes to the process, rules, forms, and practices that we're using right now as revisions are considered. And we will be conducting a follow-up that will be scheduled and announced soon. And getting that initial feedback in June was very helpful toward that. So we hope that you will watch for that. We will announce it widely. The meeting will be open to the public. It will be broadcast via Zoom, and we'll post a framework sufficiently in advance to allow individuals the opportunity to review and provide meaningful feedback regarding the testing accommodation process. So we encourage you to participate actively. Thank you. That concludes my quick announcement process.
Excellent. Thank you. Is our group ready for our special set from the Commission on Access to Justice?
You're muted, Natalie.
I do see that they are here and they are being promoted so that they may deliver their presentation. It takes just a moment for them to arrive. Do we have Mr. Jack London, the Executive Director of the California Access to Justice Commission, joining us?
I'm here.
Thank you. I'll turn it over to you.
Great. And if Judge Mark Uhas, our chair, has been able to join us, I know he has a calendar today. And also Jasmine Kadura is helping me. Let me get started. The California Access to Justice Commission has existed for 25 years. We were convened by the State Bar and operated for many years with staffing from the State Bar. Since October 2019, we've been an independent California nonprofit doing the same kinds of work and more. Our mission is to act as a site for collaboration on civil justice improvements, to midwife ideas that others carry out, and to act by way of pilot projects, research, and publications. If we could look at the prepared slides. I think Jasmine had, if you could share the screen. We have 28 members who are appointed by state officers and public entities. We have always throughout our 25 years had membership from law professors. But we also have appointees of the governor, the chief justice, the judicial council, both houses of the legislature. Let's advance another slide, 2 slides, Jasmine, or Robert, rather. You can see the list of appointing entities. If you visit our website, 1 slide back, please, Robert, at calatj.org, you'll see on our publications page the kind of work we've done over the years. We have a series of papers that we're proud of on rural areas of California and issues and obstacles to access for people in rural areas to justice. Language access is another focus. Our work in the early 2000s led to the state of the Judicial Council forming a language access plan that is being implemented across California. We were the originators of recognition of the limited scope, also known as unbundled legal services. And we're very proud of having started, along with others, the Equal Access Fund funded by the legislature, so that out of general funds this year, there will be $80 million made available to for legal aid in California from the general fund. You can advance 2 slides now, Robert. If you go to our website, you'll see in our 2021 annual report on activities, including a new program funded as part of that Equal Access Fund money from the legislature. We had last year $5 million to make grants for legal aid infrastructure and for innovative delivery methods for legal aid programs, including nonprofits that do and others that do not receive other funding from the State Bar through the Equal Access Program and the Interest on Lawyers' Trust Accounts programs. So we are oriented toward making improvements in the real world, although some of them take years to accomplish. If there are members of your faculties who might be interested in participating in one of our committees, they're also listed on the website. There are 12 of them, and our ability to accomplish things depends in substantial part on having the participation of volunteers. Many of our participants are sitting judges. We do have access to people in the legislature who are receptive to these causes, and we do get things done. Now, last year, the State Bar sponsored a study that we did. The cover page is on the screen now, on legal aid recruitment, retention, and diversity. And what we found is something that's quite straightforward, but there is today a crisis in hiring in legal aid in California. The crisis is compounded by the good news that we have obtained very large increases in funding. In the last 2 years, we've gone from a base funding of 20 million to now this year's total is 80 million in general fund money, on top of the interest on lawyers' trust accounts, which is tens of millions of dollars, and on top of the Federal Legal Services Corporation funding. But that increased funding can't accomplish its goals if the programs can't hire. There are opportunities for lawyers to get to go to work and to have a career serving the public in legal aid in California, but a huge impediment is the low rate of pay. It's quite common for legal aid organizations to prefer expanding program, hiring more lawyers over raising the compensation of their own attorneys. But for reasons of concern about whether these funding increases can be used in that way or should be, there are great disparities in the rates of compensation. Next slide, please. Robert, can you let me, let's see, let me just share with you a result of our research. We found that there is a $25,000 gap between the average starting salary in a legal aid organization in California and the low end of the range of government salaries in comparable geographic areas in California. That $25,000 gap is a major reason for the hiring crisis. Now, we recommend and have recommended to the legislature and others that the compensation be increased for legal aid lawyers. But if you're looking for the most efficient way of bridging that gap, it is to broaden the availability of loan repayment assistance for student loan balances of legal aid lawyers. Let me give you this example. That the average starting salary for legal aid lawyers in California is about $64,000, a little bit more. Now that's substantially increased from a couple of years ago. But even at that, there's a big gap between that and comparable available jobs. The average student loan balance, and I've used the average for a student of color here, which is higher than the overall average, but is an impediment to hiring a diverse staff. That's $200,000. On the income-driven program under the federal direct loans, that would be $4,416 in payments per year. That would be less than the amount of interest due on the loans. What that means, of course, is that the balance goes up for someone who's on the income-driven plan. And a consequence of that is 10 years in, this lawyer on the income-driven plan would have a loan balance not of $200,000, but of about $320,000. So the worst situation, and it's a frequent one, is that a legal aid lawyer years in can no longer afford to stay with a job, goes to a higher paying job, and the interest driven payments or the standard payments go up from $4,416 to more than double that. And the balance is no longer $200,000, it's $320,000. And if, as we'll touch on in a minute, the public service loan forgiveness program is not engaged and effective and really available, it's a terrible problem. We will be teaching, we are in the course of teaching legal aid programs how to set up a loan repayment assistance program. I know a number of your law schools have such programs already, but we are going to be presenting at the Law School Assembly on September 29, an hour-long presentation by an expert in student loans on the mechanics of setting up a loan repayment assistance program on a tax advantage basis. A tax, as many of you know, I'm sure if you have these programs, there is an Internal Revenue Code provision that allows a nonprofit to make a loan that can be forgiven. That mechanism, if it's used for educational purposes, including covering current student loan payments. So by setting this program up, the benefits of the loan repayment are excluded from the beneficiary's taxable income. The result of doing that, as this illustration shows, is that there's a substantial savings on income tax, state and California. Now, using MIT's minimum cost of living standard for Alameda County, someone with a single person with no children has to earn at least $34,000 after taxes to be able to live. With one child, it's $72,000. By making, without a tax exempt LRAP, after taxes and student loan payments, our exemplary lawyer has $45,000 to spend. That is very close to the minimum, less than a minimum with children. And with more children or other dependents, it goes up sharply. And after a tax sheltered LRAP can work a 9% increase in the take home in the pocket after taxes and loan repayment compensation. So it's the most efficient way of bridging the gap. Up one slide, please. We have engaged a consultant who's an expert in student loans, Heather Jarvis. She's one of the technical advisors to the current revisions in the regulations governing the public service loan forgiveness program. She will be addressing the law school assembly for an hour, talking about public service loan forgiveness and how to set up and implement a loan repayment assistance program from the perspective of law schools. Let me talk for a minute about public service loan forgiveness. You may all forgive me if you all know this, but as of about October 2021, the cumulative rate was 98% for applicants for public service loan forgiveness who were denied. Only a handful had been granted. That was because of quite strict, although not illegitimate, application of procedural requirements. I'll give you one. If you paid $10 too much in a loan payment, it didn't count. If your employment certification was a week late, it didn't count. As of a year ago, there was a limited waiver period which was put in place by the Department of Education that lasts through October 31st, 2022. It's very important, and this is a message for all of the law schools that are nonprofits or government run. All of your faculty, all of your staff, your custodians, you're all eligible for public service loan forgiveness. During this limited waiver period, credit is given based on months worked for the nonprofit, not payments made and duly documented. Those changes will be made permanent in rules that will come into effect, but not until summer of next year. And they will not necessarily be retroactive as they are now. So it's important for you and for your faculty and your staff to make applications that take advantage of the limited waiver series waiver for public service loan forgiveness. If any of you are interested, we're preparing a short brochure that you can circulate with your colleagues if you like. Send me an email or let Natalie know if you're interested. This will give just some summary of what's at stake in making an application. People should make applications even if you haven't yet made 120 payments or worked 10 years. If you hope to have public service loan forgiveness benefits, because there can be retroactive waiver of procedural requirements for payments already made, whether that's 1 year or 5 or 10. So everyone hoping for public service loan forgiveness and who's eligible for it should apply for the program. It's a simple process online to do that. So because this is a crisis for legal aid lawyers, we're focusing on it. We are looking for public sources and other sources of funding for legal aid loan repayment assistance. We are working with the programs to help them convert non-tax advantage programs to tax advantage programs. And we're quite interested in working with any law schools who are interested in implementing a tax advantaged loan repayment assistance program, because that is part of our pipeline for new legal aid lawyers. Our focus goes well beyond legal aid, but it certainly there's certainly a major part of our work. We are working on projects for better service for modest income people. We helped organize incubator programs to get lawyers started in practice who serve modest means Californians. And we are very interested in working with law professors, law faculties. We can generate projects that could be suitable for research in a clinical class. And we're here, we want to work with you. That is a summary of a number of things. I'd be happy to answer questions. If any of you are interested in this informational brochure on the limited period through October 31 for making an application to get the benefit of the waivers, please let us know and we'll send it to you.
Thank you, Mr. London. Any questions or comments from our committee members? Not hearing any. Again, thank you. I know this was specifically on loan forgiveness, but just out of curiosity, for legal aid, has there been an attempt to leverage the practical training of law students program, sometimes informally known as a certified law student program? At our institution, we've done that in specific.
That is a program by program. That is legal service organizations, some but not all, make use of that program. It's very valuable. It's highly valued. We'd like to do more. For example, in the second round, which we've been funded for in this year's budget, we have another $5 million for innovative legal services programs. If any of your clinical programs have, and one of the programs funded this last year is a law school-based clinical program. Mm-hmm. So you might consult with your clinical professors about whether they have ideas for innovative delivery of services that could be done using your certified law students, because we have $5 million to grant to innovative programs this coming year.
Well, I think you're gonna get quite a few emails on that one, okay. which is a good thing. As an example, and I'm very appreciative you come to the CSBARS in this regard, that for the California accredited and registered schools, many do not even receive federal financial aid. So we don't have the same loan issues as many of the ABA schools. their cash paying students as they go through. And historically, they're from underrepresented communities, first generation Americans, first generation professionals, and other underrepresented categories. So I think you definitely have a willing ear within this committee and with this class of schools, the accredited and registered schools. So thank you.
Great. Well, we welcome any ideas about what could be done to improve the civil justice system, if you call it that, but improve service to people who can't afford lawyers.
Dean Leal?
Yeah, quick question, Mr. London. Thanks for the information. As Dean Fickler just mentioned, the issue for my students isn't so much loans. They generally can't qualify and don't have loans, but getting a job that would suit their professional goals and their interests, public interest, poverty law or legal aid would be something. Does your organization, ever have job fairs or a discussion of another webinar where those opportunities are discussed? Because without the loans, some of my students might be interested. I mean, to them, working full-time as a licensed attorney for $65,000 might be an opportunity they would be very interested in. So I'm just curious about any kind of public outreach program that you have to encourage law graduates to go into public service or into legal aid.
We work closely with the Legal Aid Association of California, which has for many years, although I can't speak to the COVID time, held job fair programs, and I'll make it a point that our presentation to the Law School Assembly on the September 29 address that. We would really like to talk about career opportunities in the Equal Access Fund funded about 100 legal aid programs in California, plus about 50 others that are not IOLTA funded, but that do this work. So let us look into what we can either give you by way of information or maybe get organized and present it by then.
That would be really interesting to hear and very helpful. So I appreciate anything you could do along those lines.
Yeah, and the I'll mention the incubator programs that we helped get funded. They're still running in 2 locations, Los Angeles and the Bay Area. Their purpose was to try to get lawyers started in self-funded practices that serve people who can't afford to pay the market rate for lawyers. We'll be presenting an MCLA program on incubators later in the fall for lawyers who are in practice, not particularly for law students, but about how to get a community lawyering practice up and running.
This is Dean Park. I just wanted to say thank you for your presentation. From what I heard, it definitely seemed focused on law schools with the nonprofit structure, but I think a lot of what you're talking about is possible other topics. It would definitely be what would be interest of all law school types, ways that students can hear more about these opportunities. And I'm excited to hear about the incubator topic, specifically being there for an MCLE later this year.
Thank you.
I have a quick question. You mentioned an effort to focus on rural access and an effort to focus on language access. I'm just wondering if there's been any effort to focus on access by the homeless, access by veterans for legal aid.
We have done, well, first of all, there are large amounts of currently new increases in funding for the homeless prevention programs through EAF that we've supported. And we have several grants that we've made for homelessness focused programs. I will say that right now is a great time to be looking for to innovate in veterans assistance. That is a topic for which there's a real appetite in the state legislature. But I don't have a program that we're engaged in right now on that. We would love to. So if you have questions or ideas or suggestions, our purpose is to work with all of the appointing bodies at getting them to institution and also all the legal aid programs and incubator programs and others to try to, if you will, midwife innovations for enhancements.
Thank you.
For veterans, you may know about legal aid at work and their employment related veterans programs. They have clinics in several places around the state, and they are a very good source of ideas about existing help that's available, and it would be a good collaborator for ideas about innovation.
That's called Legal Aid at Work.
Legal Aid at Work, their head office, they're formerly known as Employment Law Center Legal Aid Society in San Francisco.
Thank you.
Elizabeth, I'll think of her name, but they have a wonderful person who runs it.
So any other questions or comments from our committee members? So Mr. Lanigan, thank you for your time. It's been a very engaging and interesting conversation.
Thank you very much. Contact us if we could work together.
Now, just as a reminder, we do have a second special set for our time restrictions at 2:15. It is now 1:59 for the first year law students exam multiple choice content review. I think, and Ms. Leonard, if you're okay with it, I thought we could jump ahead to our section on the continued discussion of guideline 1.11. We could probably start a review of what the discussion was in the previous CSBARS meeting, go to our special set, and then after that, come back to our committee for further discussion on guideline 1.11.
Excellent.
Mr. Wool, if you could please pull up our current proposed version of guideline 1.11. Again, this is from the Unaccredited Law School guideline. Again, it was in regards to a prohibition on first year law students exam and California bar exam permitted courses and content within the JD degree for context. So by way of background, this has been an ongoing project for our group. I think it's been a good collaboration in which, again, as our committee broke up into separate teams, we reviewed different versions of the proposed language. Ideally, we would definitely enjoy getting committee member Kramer's feedback and Mr. Murphy's feedback at this current stage. So what we see on our screen is our latest incarnation of our proposed language to hand off to the committee. So this gives us a final opportunity as a collective group with all of us within this panel discussion this time, and in case we want to make any changes or alterations, or potentially Mr. Murphy or committee member Kramer has any specific areas they think we should go into more detail about, or more specific as we have that discussion.
And Chair Frickberg, for the benefit of the public, for those who might be joining in on this discussion for the first time, would you mind just recapping in a sentence or two the purpose of this guideline and amendment?
Yes, the original issue that was presented to us within the CSBARS is that the existing guidelines and rules prevented the registered unaccredited schools from having a bar review. Especially with our discussion we just had on the opportunity mission and inclusion within the bar, that seems to fly in the face of the idea that we want people, especially first generation professionals that might not be able to afford their own separate bar review, to have access to some bar review type materials. And it became a discussion internally of what should that level be? You know, should it be 100% bar review for 3 to 4 years, or I guess in their case, 4 years for a registered unaccredited school, or no, which is the existing rule. And we're trying to find where is that in between point? Where is that in between point? And then I think the really thorny issue that we saw fleshed out in our conversations was, how do we define what a bar review is? You know, what is a bar review course? You know, that varied greatly. And this is a flashback for those that weren't part of that conversation in the public. One of the debates involved remedies. Remedies is a bar tested subject, but remedies itself as a bar tested subject includes contracts, torts, and property issues. So does remedies count as a bar review? I think most of us would say no, inclusive of the bar, since they identify that as a separate subject. You know, to the other extreme of academic support. You know, is academic support itself bar review? Again, I would argue no, and that I think bar review is specifically targeted, and that's where that interesting language about the first year law students exam, the general bar exam, the standardized tests that the California bar examinees administer. You know, a bar review is designed to help someone in a pass-fail test, right, to meet that minimum competency standard on a wide breadth of material, versus academic support, from our discussions, has been more in-depth. You know, we're trying to not only help a student pass a course, but to excel in a course. You know, it might be the distinction in academic support of not so much from a F to a D to a C, but a C to a B to an A, you know, to a mastery of a subject matter within their understanding. Was that helpful?
Yes, very much so. And previously, the registered schools have always been able to offer a bar prep course, just simply not for credit. And the CBE asked for feedback about potentially permanently changing that, allowing some bar review program to be offered for credit.
Excellent distinction. Thank you.
Mr. Chairman.
Your hand up, please.
Mr. Chairman, I just want to add briefly that the studies show that graduating students who take bar exams and bar review courses increase their likelihood of, and complete the course, increase their likelihood of passage on the bar exam. And so allowing the schools to grant credit for these courses, it seems to me, helps meet the mission of the state bar, and also the schools to see qualified people admitted to the bar, particularly those who are among those who are historically disadvantaged groups. So I think this is an encouragement. I do not think it will adversely affect the educational programs of the schools.
No, definitely. Thank you. And I think that went to some of the discussions we had internally within these conversations as the different teams presented their draft versions to get to this current draft version of it. Is it counter to the academic integrity of a program? And I would agree with you. I do not think it is. And again, I think it's unique in the facet of training lawyers. It's not so much the degree as terminal, but it is, in my phrasing, the ticket to sit for the bar to acquire your license for practice. And that is the terminal component of our educational process. That is the ultimate capstone in our educational language to confirm the validity of the educational process. So I think it is very helpful. Mr. Murphy or Committee Member Kramer, is there anything you'd like us to discuss in, or at least reflect on before we go to our special session?
I have no further comment.
Let's see, we've got how much time?
We've got time.
Okay, yeah, let me, I do have a bunch of comments, and I think
Please.
it's to your advantage to hear them today as opposed to, say, when it's presented at the CBE meeting, because we can probably talk out some of them and come to a meeting of the minds rather than an agreement to disagree. Let me, Robert, if you can stop sharing, I have a version of this language that I've marked up that will illustrate my points. So let me press my share button. Is that of a sufficient size that you can all see it? Because I'd like to have, I'm on my laptop because I'm on vacation. And so I don't have as big a screen as I normally would to put two documents side by side. Is that okay?
For me, it is. I can read it clearly.
Hello? Okay. Anybody having a problem viewing it? I could make the font bigger if I needed to.
Just a hair, Paul, if you could. For those of us
Okay.
with sight impaired. Thank you. Yeah,
You mean like 2 points or 4?
just
How's
two,
that?
Yeah, that's, yeah, that's fine.
Okay.
Thank you.
Too much?
No,
Okay, we'll leave it there. All right. So I think there's one typo in the first paragraph of your definition that you can see here in track changes, minor issue. I had an alternative formulation I came up with, which is this, it's a complete insertion here in the second paragraph. You can take a look at that. Sounds like we'll be mostly discussing afterwards. And then, let's see, what's my justification here? I do agree that what we're trying to do is make sure as basically repeating elements of, that are in the basic classes, generally speaking, contracts, torts, con law, criminal law, for the main purpose of preparing for the bar exam. And your definition speaks to a focus on standardized testing, timing, closed book, kind of the tricks of taking a test. But unless bar review has changed more radically than I can imagine since I took the bar exam back in the early 80s, it's still mostly a matter of learning the basic points of law. You can apply them to the questions as you see them on the bar exam. And I don't think your definition really gets to that. I am concerned that law schools become just bar test preparation machines and not, do not expose potential lawyers to a wider breadth of the topics, the subject areas that they may ultimately practice. And so I am concerned, that there be a limit on it. You folks have talked about a limit in the form of, I think your formulation might cause some confusion down the road because not everybody has uses semester units, as I understand things. And they may require a larger or perhaps a smaller number of units because they equate them differently to the hours or for whatever reason. So because your formulation converts to basically 15%, I think it would be cleaner to just say a maximum of 15% of the credits required to obtain a degree. And that would self-adjust for whether, you're a school with 80 units required or 120 or whatever. And then, let's see, stepping back above, just as a matter of drafting, the term commercial review pops into this paragraph here. Are you seeing my cursor move?
Yes.
Yes.
Okay, so this paragraph that I'm waving my cursor about. And so I just changed review to test preparation just to relate it back to the definition. I don't know that would cause any concern. I highlighted the phrase grants credit because you may also recommend courses to students. I think my law school did, or maybe they just had a list and anybody could be on it. But to the extent you're recommending a course to a student, whether or not you grant credit for it, I think the student should be able to know if there's some kind of a relationship that may affect their decision. So in other words, the disclosure should be more broad. It should be whenever you recommend a course, whether or not you grant credit for it. And that's the point I'm making there with that phrase that I highlighted. Now here, right after we talk about the 15%, this sentence that's highlighted, I worry that this basically blows a hole bigger than the size of the requirement in the requirement. In other words, it negates it. It was suggested to me that I listened to the last meeting, and I did, because maybe there would have been some discussion that would have explained this for me. And maybe I could at least understand it and perhaps, offer my own words to achieve that goal. But I did listen to the meeting and I didn't hear anything. So we need to talk about that. And let's see. That's the extent of my main comments. During the next presentation, I'll take another look at my notes and see if there are any other aspects I need to highlight, just to make sure so I don't accidentally surprise you with something after we've had our discussion today.
So
And now my
excellent.
internet connection is unstable.
Well, it has been. Every now and then you slow, then you speed up. But for the most part, I think I could understand it. It might also
Okay.
be your screen sharing. I think that's using part of your bandwidth, because I didn't hear any issues until you did the screen sharing.
Okay. Do you folks, you probably want it up though, so you can look at it, right?
Is there any specific areas we'd like to have a discussion for 2 minutes, just because of our special set? And then once our special set concludes at 2:30, that'll leave us another 30 minutes as a group. Then I believe to discuss, debate these proposed amendments and see if we can come to consensus, which is always preferred.
Mr. Chairman, this is Greg Murphy.
Please.
As it happens, I've accepted a referral from Montana Legal Services, and something came up after this meeting was scheduled. So I'm going to have to leave at 2:30 your time. So I'll just offer my comments. And I know you all will, by appropriate vote, do the right thing when I'm gone for this meeting. I don't have any heartburn about any of the suggested amendments that have been proposed here.
Excellent. So it would be fair to characterize then you would be fine either with the proposed changes or the existing version?
I would.
Okay.
I think some of the proposals bring some clarity, and drafting. I mean, as instead of bar review course, commercial preparation course, that's what we have in our elsewhere. We should try to stay consistent with that. So, and I don't otherwise see as I say, anything that substantially gives me any heartburn.
Excellent. Thank you for that. And thank you. For
Either
your
way,
comment.
as far as I'm concerned.
Understood. Dean Clancy, you have your hand up.
I'm sure there may be others who would like to make some comments about the proposals made by Mr. Kramer. I'm wondering if, before we do that, is there time to add other suggestions in the way of wordsmithing? I have a few of my own. Should I hold on to those or not?
Yeah, let's hold on to those, because I think we can do that once we come out of our special set at 2:30. I just want to be mindful of their time as well as our time as we go through, and it is 2:15 now at this moment. Dean Leal or Dean Clancy, was there anything you wanted to state before Mr. Murphy leaves us? Because he will not be back when we come back after the special set.
No, I can wait until after we come back. So
Same for me.
Okay, thank you. Ms. Leonard, is our group for our special set at 2:15 ready for our first year law students examination update?
I believe we have Lisa Cummins, and Lisa, do you have Mr. Buckendahl with you?
No, he was sent a separate link, right? So he should be joining. You don't see him in the audience?
Yes. Robert,
Would his
does ACS Ventures, please? Yeah.
Mr. Chairman,
just
while
wanted to confirm that.
Yes. So I'd like to welcome Lisa Cummins, working with examination development here as part of State Bar staff, and also Chad Buckendahl, psychometrician involved with the creation of our State Bar exams, coming to you from ACS Ventures. And they'll be talking about some plans that will be taking place as part of the October first-year law students exam. You heard a brief summary of that at the last meeting, and we have some updates to share today. So Lisa and Chad, thank you for joining us today, and we look forward to your presentation.
Mr. Chairman, may I just be heard just briefly before the new set starts, since I don't want to interrupt once they get into their presentation. This completes my service on CSBARS. I want to thank the State Bar of California and all of you for your courtesies and kindness and patience. I hope I contributed something. I think I contributed more in previous years than I did this year, just because of the matters that we were covering. But thank you for the opportunity, and I wish you all the best in fulfilling the missions of your schools.
Definitely thank you, and it's appreciated. And I think you
Frank.
did provide a lot more than you think you provided. Yeah, it's definitely been helpful, even in this conversation today. So with that, let's go to our team from our special set on the first-year law students exam multiple choice.
Okay, thank you. Good afternoon, everybody. So I'm just going to provide an update, and just as a recap, the State Bar announced this project to review the multiple choice content portion of the first year law students exam. We announced that in mid-April of 2022. We sought volunteers. There are two phases of that review. The first phase was the content map review, and the second is the item review. We did the phase one content map review was completed by 13 law school reviewers, completed in May of 2022. I did report on that phase at the June CSBARS meeting. So I want to update you that phase two of the project, the item review phase, will be starting. Right now, we did just send out an email to the same 13 reviewers who participated in the phase one of the project. We sent that out today earlier. And so hopefully we can start scheduling those meetings. So what will happen with those is that there's an initial 1 hour full group orientation and training session to be conducted by our State Bar psychometricians. Thereafter, subgroups of reviewers will be reviewing different sets of individual multiple choice items with State Bar staff facilitators. We're planning 4 to 5 meetings of about 2 hours each for the first round of review. There may be necessity for additional shorter meeting if it's needed to resolve any items that require, that have some controversy involved. And then meetings will all be conducted remotely via Zoom with breakout rooms. And for exam security reasons, the item review cannot be done outside of those scheduled group Zoom meetings. I also want to update you or kind of correct some information I provided at my last update, which was originally I had reported that with the October 2022 first year law students exam, that we would be piloting 25 new multiple choice items. And originally I had thought that we were going to be scoring all 100, but instead scoring 75 and not scoring the 25 new items. But what we will be doing instead is an operational pretest where we will score all 100. And I will be having Chad Buckendahl, our psychometrician, explain to you what an operational pretest is and what that will entail. Chad?
Sure, thanks, Lisa. And yeah, I know it may sound somewhat oxymoronic to say operational pretest, but essentially what you're doing is because the examination has 100 questions associated with it, you'd like to be able to score as many of those questions that meet the content expectations as well as the statistical properties. And so typically when you're introducing new items to an item pool or an item bank, is you pretest those items out, you treat them as unscored, and then you add them to the bank. However, in doing so, that typically means the exam is longer than what a normal length exam is. And so to try to cut down on fatigue, and is something that is becoming more common in practice, whether it's in educational testing programs or other licensure and certification programs, is the idea that you introduce, in this case, 25 new items that you want to add to the pool. You administer them just like you would a typical experimental item, but then you reserve the right to remove any of those items from the operational scoring that do not meet the statistical properties that you establish for the program. And so in effect, the value of doing so is you get more content representation and typically a more reliable score, because you have more information on which to establish the pass-fail decision. But you're doing so in a way that if all of those 25 new items perform well, then you're scoring it based on 100 questions, which would be more reliable than just scoring it on 75. But it is called an operational pretest because you are using the scores operationally, because you have a motivated group of students who are taking the examination, but it is still technically a pretest of at least some of those questions, so that you can be confident that the statistical properties of those questions do meet kind of minimum standard for inclusion as part of a score, so that examinees, or students in this case, are not disadvantaged if a question doesn't function appropriately.
Thank you, Chad. Are there any questions about the what has been presented thus far? George?
Hi, Lisa. Yeah, Chad, just a quick question. Are what you're saying, if they were to find that, say, 10 of these new questions didn't meet the statistical parameters, they would be taken out and students would be then graded on the 90 that passed the muster?
That's correct, yes. Yep. So
They
we
would-
know we have, sorry, go ahead.
No, you wouldn't throw out the whole bank of the new 25 if 15 of them seem to have performed as expected.
Correct. Yeah. Each one of the 100 questions functions as essentially independent observations. And so ideally, we'd like to have 100 independent observations of the student's knowledge in these content areas. But yes, if 10 of those items don't work well, I'm still pretty confident with 90. And the reason that we're suggesting 25 for the kind of the pretest piece is we know statistically that if all 25 don't function well, even with 75 questions, we're going to meet kind of minimum expectations in terms of reliability. But we know that with more questions, we can get to an even more reliable decision. So 75 is kind of the lower bound, with a hope that the additional 25 questions will perform well statistically, eventually be added to the item pool, but also, provide us a more robust estimate of the student's ability.
Yeah,
Mr. Chairman?
I'm sorry.
Your comments, this is Greg Murphy speaking. Your comments just now actually relate to a question I was going to ask you from earlier in your presentation. It's been a while since I've been in the bar examination game, but I had long understood that one needed close to 200 questions in order to achieve a reliability coefficient of 0.90, which you want on a high stakes examination. Would you care to, that's quite a bit less than what you're basing on. And I just wonder if you'd like to comment about that. I may be wrong now. Maybe the profession has moved on from 200 questions or on that many, but I recall that was a pretty standard, or close to 200, pretty standard, at least with respect to the multi-state bar exam.
Yeah, Mr. Murphy, that's a great question. And what I would say, even some of the psychometric science has improved over the years. You can actually get to an incredibly reliable score with usually around like 40 to 50 questions, with some assumptions around how those items function. And so part of the reason to have at least 75 to 100 questions is we want to ensure there's good content representation, in part for the subscores. So for the 3 subject areas that are tested, we want to have at least 33-ish questions for each one of those for the subscores to then have some meaning for the students who are taking it. And yeah, from a statistical reliability standpoint, yeah, you don't need quite 200. In fact, even the multi-state bar exam now, the multiple choice portion, only has 175 scored questions, and they likely could get by with quite a few less. But with 7 subject areas, they have, I think, 25 scored items per subject area, and then 25 pretest questions that are included for them to try to just help build the item bank out.
I had a question or a comment. Is it fair to say that the first-year law students exam is perhaps not of the same level of, what was the phrase we were using? Anyway, it's not a gateway to the profession. It's simply a gateway to the years 2 through 4. So perhaps the degree of correlation required is maybe a little bit lower.
Mr. Kramer, yeah, that's a very good question. And as an educational exam, yeah, we do sometimes, if it's considered lower stakes, that maybe our expectation of reliability, and in this case, internal consistency, sometimes we may accept 0.8 or 0.7 in terms of that correlation coefficient or the reliability coefficient. I think because there is an expectation that this is helping to make a decision about whether a student, should progress or not, we still have that target of an internal consistency, or at least an overall reliability of 0.9, because what happens is it's not just the multiple choice test, but it's the multiple choice test plus the essay question for the first year law exam. For the for the bar exam, obviously you have multiple essay questions and performance tests associated with that, which contributes to the reliability as well.
George, you have more questions? You're on mute.
Sorry. Yes, if you could, I know this is always I guess a running debate among psychometricians, and back in the day, the committee, and I remember sitting through meetings, is the distinction between validity and reliability. I know a lot of emphasis is really focused on reliability, which is of course important, but I'd be curious as to whether or not what the test scores show in validity, and whether that's part of this review process is frankly just to make the questions more valid to the goal, which again isn't for licensing purposes, but it's more foundational understanding of law and some of the skills that students need to have to move on and succeed and graduate.
Yeah, Mr. Leo, that's a great comment and an opportunity to talk about some of the pieces that that Lisa has been spearheading on the review process. And so psychometricians appropriately say that reliability is necessary but not sufficient for validity. And so reliability, we need the consistency from a statistical standpoint, but on the front end, the review process, not only of the test specifications, meaning within these subject areas, what are the critical areas that should be measured? And the committee that reviewed that through a lens of, is the content something that is important for a first-year law student to know and understand? And is it appropriate? Is it at an appropriate level? So you don't need to be an expert in it, but you should have more than just kind of working knowledge. And then so that's part of a validity review, content validity, kind of content and process. And then the secondary part of that is not only are the test specifications targeting the right thing, but for the test questions themselves, which is what Lisa was talking about, that review is starting here very soon. The entire item bank is going to be reviewed relative to these revised content specifications. to then ask the question of, again, does the content now match one of the things in the blueprint? Is the content important? Is it at a correct level? And is it structured in such a way? One of the things for multiple choice questions in particular is we do want the distractors to represent common errors or misunderstandings about the concept that's being tested. And that's whether it's for a bar exam or for an educational exam, because we're trying to distinguish whether or not somebody knows and understands the material. And so that validity argument does start with the content specifications and then connects directly to the questions. And so that validity piece is definitely, I would say, the bulk of what's being looked at in this project. The reliability component then just becomes some of the statistical analyses we look at on the back end.
And just to follow up, so on the validity side, is it more subjective versus the reliability is more statistically, data driven in the sense that you get to that, goal of 0.9 reliability, but validity, it's going to be the professional opinions of professors teaching contracts, torts, and criminal law?
The validity is largely more human judgment, is particularly when it comes to the content piece. There are some statistical analyses that you can run for validity when you have multiple examinations that purport to measure the same thing, and you can run correlations between those things. Like if I was building a reading test, I could compare multiple reading tests, having the same people take them, run correlations to determine whether or not scores are meaning about the same thing as an indicator of validity. The reliability piece, though, there is a kind of a two-pronged element of that. It's really kind of pure statistical calculation as it comes to the multiple choice portion, and then the multiple choice combined with the results of the scoring of the essay question for the first year law school exam. But there is also a validity piece to that in how the scoring rubric is comprised, how training and calibration of the reviewer, of the graders for the essay question occurs, which is part of the validity argument to say we're providing some consistent procedural aspects in addition to the substantive elements that we're measuring to ensure that then the scores that are produced and the decisions that we're making are consistent. So there is like a little bit of human element because of the human scoring associated with the essay question that kind of combines validity and reliability.
And just the last point to your point, I mean, I guess the process is a handicap to the degree that our first year exam here in California is, to my knowledge, unique. You can't compare, I don't know of, maybe others do, of another entity testing the standardized level or base level of knowledge of first year law students. So we've always been kind of out there by ourselves. So it must make, and I guess this is just a comment, it must make the validity part of the exam a little bit more difficult to there's nothing to compare it to, and just something to be a bit more concerned with.
Correct. And it is something that is largely then based on the consensus of subject matter experts who have knowledge of the content of first year courses that are measured on the exam, as well as familiarity with the abilities of the target population of students who are actually taking it. I mean, just as a research concept, you could conduct validity analyses if you, if you had some schools willing to partner with you to provide grades or scores from, their contracts or their torts or their criminal law courses, to be able to then correlate parts of the examination with that, to do some of those estimates. And there's some assumptions that you would make about it, but that would be at least one way to kind of test the concept.
Thank you. Mr. Buckendahl, I had a question, just more of a confirmation. I'm not a psychometrician. It's not my background. I do have an interest in the data, of course, just because of my vocation, being in education. And my instinct reaction, emotional reaction to adding operational pretest of 25% was definitely negative. But I think you were helpful, and I want to see if I understood this correctly. My frame of reference is the NCBE, MBE, the 200 questions that we were referencing informally. Historically, 190 out of 200 were tested of that when there was 6 subjects. And when they switched to 7 subjects at Pro, then they reduced that to 175 to have more pre-test. So that comes out to 25 questions. The first year law students exam tests 3 subjects. So you think it would be a similar benefit of having 75 questions. And if I'm understanding correctly, that by having the operational pre-test, no one should be disadvantaged in measurement of their knowledge, but it could be to their advantage to give more opportunities to evidence that knowledge on the test with the operational pre-test. Is that correct?
Yeah, that's correct. And part of the rationale too was the examination has been 100 questions. And so we talked about potentially adding pretest items to it, but then we started to worry about fatigue a little bit. And so we said, well, what can we do? How many items could we potentially pretest and drop the number of like existing items that go on a form and not go over that 100 item limit, so that the experience for the student is the same, but the program can still continue to add items to the pool so that they're representing, current refresh sorts of items. And so there's no disadvantage to the student at all. And as you said, there is an opportunity then for them to have multiple opportunities to demonstrate that they understand this content.
Yeah, excellent. Thank you. Sorry for us taking more of your time than we originally allocated, but I think this is of a special interest, especially to our registered unaccredited schools, with their students being required to go through this, or even special students at the accredited schools. So it's definitely a good conversation that puts out into the public, what most people are not aware. And I think light always helps on these issues. So thank Ms. Cummins, Mr. Buckendale, thank you for your presentation.
Thank you.
Thanks.
So with that, if it's possible, Mr. Wool, do you have a Word editable version of our last version of Guideline 1.11? If you could present that, please.
Yes, I will go ahead and bring that up. And Chair Frickberg, given the time at 2:40, if you determine that it's appropriate to focus on this alone so that you may complete your recommendation to the CBE, then that would be appropriate.
That would definitely be my preference. Hopefully we'll have consensus before we get to there and we get to our remaining 2 items after that. But if not, my preference definitely would be to give committee member Kramer and the other committee members all of our thoughts on this process as we go through it.
Okay,
There's only 5 points of conflict potentially, as I was taking my notes from the conversation.
So this is the committee's version as of the June feedback without the additional adjustments from Mr. Kramer, and we can go back and forth as we need to see them.
Okay, excellent. Is it possible to put, I believe the first one was just a definitional issue as to the second component in that first paragraph exactly. Or was the phrasing of the second point, yeah, right there. I think that was the only part that was in controversy. From my quick read of it, it appeared the first point was identical.
Well, would it be better for me?
Yes, I think it might be better to,
was-
if we can share yours, Mr. Kramer.
Okay, it tells me I have it up. Is it working?
Yes.
Yes, thank you.
Okay, so yeah, there is a very simple change to the first paragraph of the definition. If that
No, my question
is the one you want,
Kramer.
but then there's
you can hear us.
a
You broke up
suggestion
for
of a rewrite
second.
of that paragraph.
Can you hear me? Okay.
Yeah,
I was my question for you was, is it more the addition of that specific language of first year law students exam, California bar exam, or the deletion of the information that was already there?
It's probably a combination because both versions mention them. It's the idea that it's rather than just aspects of the preparation for the exam, which is what you seem to be focusing on in the second clause. I just talk generally about preparing them to take the exam. Because I think you could have a lot of them, outline, memorization, and discussion time without perhaps falling under the definition in the second half, your definition, that is, because it wouldn't be about timing, whatever closed book means.
We're going to our other committee members, just on that one issue of the alternate definitions for the second component. Dean Keller.
Thanks. Yeah, I wonder if by eliminating some of that, we are introducing some potential either overbroadness or ambiguity in that now it says, subjects previously tested on, for example, you alluded to a remedies class. So that would fall under one. And then with a primary focus on preparing the student to take, say, the California bar exam, I'm not sure how I would define that, for instance, thinking about remedies. I mean, part of why we are offering remedies is because we are told we are either supposed to or have to, because it's topics tested on the bar exam. So my understanding of why we had some of that language about particularities of the examination specific to either the first year or the California bar exam would be to try to limit the definition to those things which most people think of as bar prep class, i.e. excluding something like a remedies course.
And Dean Park?
Well, I don't see remedies as covered in this one, but as a bar prep course, because it's introducing new information, but in the context of disputes or issues that come up that also relate to the other fundamental topics of the first year.
So I would respectfully disagree as someone who has taught and teaches remedies, that a lot of my remedies discussion and the material within the text, the casebook, the horn book, is a review of contracts. UCC common law is a review of torts, is a review again of property. It's just more of a focus than added with extra equitable issues. So I think that's part of our conversation at that time was, how do we separate out a traditional law course, a bar tested substantive subject? I don't think anyone would normally argue based on that definition. That's why we were so focused on, in academic support, we're not focused on time. We give our students time to learn, for that material to hopefully sink into a deeper level. And also closed book, the bars are closed book in that they're not allowed to have outside resources. But in an academic support environment, they're allowed to have outside resources. They're not there to earn a grade, they're to learn the material and hopefully master the material. So I think that was part of our concern. If it was not defined specifically enough, is that going to cause conflict later in application?
This is Dean Park, and it does say my internet connection is unstable. So forgive me if I do go in and out. I'll try to speak quite slowly. So I think I appreciate, for example, any consistent use of a term in drafting. And so, for example, if we have defined test preparation course in one place, it's good to use it consistently throughout that guideline. And it's good, especially if it hasn't been defined elsewhere. And I did want to address Paul Kramer's point about closed book, that at least for our law school, that means they don't have access to notes or a copy of their book. They're really supposed to take the exam with what's in their head. But if there is a better term for that, maybe that's not just localized to law schools. I'm open to it. My concern about the alternative formulation, although I like some ways that it simplifies things, is that test preparation courses really can be more than what's focused on the FILXX and California bar examination. So I think you need to keep including, even though it's redundant, it feels redundant, that reference about what kind of test preparation courses these are for, because ambiguity can be created if, you're creating a definition that doesn't actually cover what it's defined to cover. And an example of that is, I don't think our law schools are doing it necessarily, but that there could be other tests like MPRE. And just because our definition doesn't cover it, it still can cause confusion that we've sort of defined this term and yet it may not cover all the tests. We know why we want to regulate this area with baby bar and California bar examination test preparation courses, but just for someone else to operate with the language, it might help to, again, basically keep what we had in our group drafted definition, just to avoid, I think, sort of quibbling like that. The other thing that I was a little bit confused about in the alternative formulation is usually when you have contained both of the following, it's 1 and 2. And here it's 1, the review of subjects previously covered within the curriculum which are tested on. So on feels like part of an incomplete sentence. And then with is the conjunction that's between the two. So I just want to check, is there missing language there, especially after the on, or just
The on is meant to refer to the reference to the first year and bar exams.
Okay.
We could repeat it. It just becomes,
wordy.
Awkward. Yeah.
No, I hear that. I think in this case, it might help to repeat it, just because otherwise, for someone reading through, they may think it's incomplete. Yeah.
Just to jump in to follow on that, I read it and I thought you meant which are tested on in those classes that previously covered the subjects, not which are tested on other future tests. So I think that, for what that's worth, I think that clarification would be helpful.
Okay, I just did something to it there.
Oh, okay. I didn't realize editing on that end, but I appreciate that. The other last comment I wanted to make just about assessments, I think why 2 was as detailed as it was, even though it's wordy, is that, and this comes from my review of law school courses and what they defined as bar prep or not. You do have classes that have different format and assessment that are not standardized timed closed book examinations. And so I think it's important to be clear that test preparation courses are not covering that. And just to give some examples, there are capstone courses that will cover exam practice, but that won't, and among other things, such as reviewing subjects prior to that, but they're not producing an assessment like a standardized time closed book. They may be producing something else that reflects their knowledge and kind of adds to their portfolio. So even though that language in number 2 was wordy, I do feel it made a distinction that's helpful. And it would have helped me to go through and filter out correctly the law school curriculum I was looking at 7 law schools with Dean Clancy, I think, compared to the alternative formulation that's proposed. And that's my input.
Any other comments, questions from our committee members on that limited definition? So I'm not sure if we're going to be able to reach a consensus on that one. I think we can circle back with time remaining today, but maybe we can advance to the next proposed change, which is the phrasing of review versus test preparation, and was that the fourth paragraph below? I'd be supportive of that one. I think that goes to what Dean Park was mentioning just now, and then in previous meetings, the consistency of language. So I'd definitely be supportive of the change of review versus test preparation. I think that's more accurate and consistent. Any discussion from our group on that limited issue of review versus test preparation?
I agree with that, making it consistent from the very first sentence when we refer to test preparation courses. So I think that makes a good change.
Dean Leal, I agree. Would think that's a good change.
Excellent. So I hear no opposition to that. I think that will definitely be part of our consensus answer as we go forward. Now there is a third issue of the phrasing grants credit. Committee member Kramer, if I remember our discussion before the special set, you would like to add additional information about recommendation. I'm not seeing that there. Is that something you wanted to add right now?
Let me propose something, sure.
Now, my only
Maybe
thought,
you take out the it's and just say,
I think it's a good starting point for our dialogue. My first thought, and it was just or recommends to its students. I think that's going to be I'm just thinking an application as an administrator. How do I evidence I did or did not do these things? If it is, I think it's very common for law schools to have, in essence, a public board, physical or virtual, where anyone who would like to put information, bar review information as an example, I don't believe that would be recommendation. Maybe if we had language, I don't know if this is going too far, but recommends uniquely or specifically to its students. I think that's versus just anyone who would like to put a bar review out, we'll put your information out for the public.
Okay, so one more time, recommends
uniquely or specifically to its students. Because that way, if we're treating all bar reviews the same, then we can say we're clearly in compliance with that.
Right. Well, let's see. So if you're just listing resources that you know of without endorsing them.
Exactly. Because I think that's very common in my experience that, the bar review companies, and they could be brand new ones or large national ones, will say, can we put our information out? And I think all law schools historically would say, yes, of course you can. We have this table, we have this bulletin board, we have this virtual bulletin board online. But I don't think that would be crossing that line of recommending. So if we treat all of them the same, we're not giving anyone an advantage in essence.
And you get more free snacks or water bottles or whatever they're handing out.
Personally, for my institution, I always make sure they bring something for the students. Yes. So if they want space, they have to give something to the students, which is usually pizza historically. So from our committee members, any thoughts, questions just on the limited issue of the additional language of or recommends uniquely or specifically to its students, for triggering that disclosure requirement if there's an interest or self-dealing, I think is the shadow of the concern.
That change addressed my concern with the idea of recommends. I think that limits it appropriately.
Anyone counter to that in being included, that additional language as presented? Dean Park?
This is not a counter, but I'm just thinking back towards why we came to the group draft before. I think it was just the question of evidencing compliance and also making sure that people understood what triggers this this rule, that they can understand that consistently. So I'm wondering if promotes might be a better word than recommends, because and just in terms of language, usually for consumer protection, if there's a trigger, promotes, it kind of implies that there is some marketing being done by the law school to take a specific exam, whereas recommends, I feel like that can, you know, how do you talk to your academic support people who write replies to their students all the time about matters? I mean, they would often describe what they're doing as recommending, but not necessarily promoting. So to me, I'm just more comfortable, if we're going to add language at all, that it's going towards a consumer protection issue, which is we want a law school that's promoting this external commercial test preparation course to disclose, but not something that it might be something more of an academic support event. And I know already we mentioned you can just list all the bar review courses appropriately and not trigger this, but I think I'm just thinking for the law school side, that might be a bit much. Maybe it's really promotes here. And let's say you tell to your students they need to take this certain class, or it's really, you know, one of the two that you push them to take. Like, I think it'll just be a little more clear how this is triggered compared to recommends.
Would that still carry the uniquely clause with it?
That's a good question. I thought it was promotes uniquely or specifically, right? Because that's like a directed promotion effort. So I thought of keeping it.
Okay. Should I type it in, folks?
I'm neutral on it. To me, Dean Keller definitely give the thumbs up.
Chair Frickberg, as to a time check, we are about to approach 3 p.m. You may want to assess whether the group would agree to stay for a bit more time.
So with that said, we still have 2 more that we have not discussed, plus a potential reflection again on the definition issue that we passed over, since we didn't have a consensus on that. Would it be okay for us for maybe another, I'm guessing 10 minutes? So, any objection to that from our group?
Well, I'd like to go over because I do have a couple of comments in addition to what we're talking about now.
Okay.
Nope.
Mr. Chair, I've got a bit of a conflict. I'm supposed to be on another Zoom meeting exactly at 3. I can probably stay for another 5, maybe 10 minutes at most. I don't want to destroy the quorum though, if there's going to be a vote. So
I think quorum is established at the beginning, and
okay.
Oh, no, is that right, Jean?
Quorum must remain at the time of the vote, but we will be at quorum. We need 4 members for quorum.
Okay.
Excellent.
All right. Well, then I'll stay and let you know when I need to leave.
Appreciate the question, Dean Liu.
So it leaves us potentially 10 minutes. So going back to the phrasing, we were at promotes versus recommends. Any objection to promotes? Okay, not hearing any. So I think we have consensus on that issue. The next one I had calendared from our previous conversation today was the 12 units as compared to 15%. Now, this is an area I'm more ignorant on my side compared to the registered school rules as we go through. Is that going to make a distinction for the registered schools? You know, how many units in essence is their equivalent? I believe we were getting to the 12 units as a comparison to the externship restriction. That was part of our conversation. So for those that are, especially with more knowledge in the registered unaccredited side, do you see a distinction between 15% versus 12 semester units that are equivalent?
Well, let me speak to my program. I'm comfortable with the 15% because it's with our new program, it's 80 units. And so we would be able to offer up to 12. And currently I've designed and our students have access to only 6, 2 units for a first year prep and review course and 4 units for the CBX prep. So I'm comfortable with that. I think it eliminates the potential confusion. I know I'm always confused when it talks about semester units or the equivalent. And it sort of puts the burden on whatever the quarter system or something else that make sure that they're compliant. So I think 15% actually isn't easier from a regulatory compliance perspective.
And from the quick math, at 8 units, it is 12 for 15%. It's identical.
Yeah, right. I'm saying I've got room to grow if I need to, but so I'm fine with 15%.
Dean Park, you have your hand up.
Yes, I know that the guidelines really sticks to semester units and equivalent, but to me, the 15% is clear. I have a 140 quarter unit program, and I know what 15% of that is, and I know how to steer safe of that, even if I get a fraction. So I don't see a problem with the 15%.
And Dean Clancy?
I'm also okay with that revision. And I'm mentioning it because I think it was Dean Park and I who suggested the 12 unit limitation, but this revision is fine.
Excellent. So do I hear any objection to the change from 12 semester units or equivalent to 15%? Is there any objection to that change? Okay, hearing none.
No objection. I just want to make sure we do maintain that footnote. Because
which is that footnote?
The footnote, I think on the original said that this is not necessarily a recommendation of CSBARS, but should there be a cap
understood.
placed,
That's my understanding. And Ms. Leonard, correct me if I'm wrong, we're going to include that notation that the recommendation from CSBARS was that there would not be a limit, but if there needs to be a limit, this would be a limit that CSBARS would be supportive of.
That's what I understand the CSBARS intended, yes.
Thank you.
Did that make it into the minutes?
Yes, it did.
Okay, good.
Excellent. So, and that's a good catch. So I think we have consensus there. So our next one that I had flagged from our conversation today is that yellow highlighted portion. And it's my understanding, Committee Member Kramer, that you wanted more of a deletion of that yellow highlighted portion. Is that correct?
Or at least it's written in a way that I understand it.
Okay, we can try either one. So the goal here is actually very similar to the conversation we were having on the definition. And it's the apprehension on our administrative academic side of how are we going to separate out what portion of a course is quote unquote bar review, potentially in a remedies, in a contracts, in a torts, because often you'll have conversations on how do you approach an essay, how do you do multis in that domain. That was our logic. So I don't know if that helps clarify what we're attempting to convey. I think we might have a bad connection with our committee member Kramer. Now, does that mean we can just accept if he does not object any additions and changes we make? Probably not.
Okay, I'm stopping sharing just for a minute because you're breaking up on me.
Excellent.
Good try.
Not that I would, but
sorry. I don't know. I'm in a timeshare down in Del Mar, and maybe somebody ran a microwave because that took me off once before. So I missed your explanation, Jay.
So the explanation was a concern on the academic administrative side. When these rules and guidelines are applied later for an accreditation visit or review or a registered version of an accreditation review, how do we separate out a remedies, a contracts, a torts class, a specific bar tested substantive domain subject, when there could be conversations within that focused on, oh, this is how you would approach an MBE multiple choice question in contracts. This is how you approach an essay. So we were just trying to parse out that language. So we're only focused on real bar review, first year law students and general bar exam.
Yeah, in other words, of course, we all realize that the bar exam isn't graded on the quality of the legal writing, correct?
Correct.
And if
Our-
you've been to
our
any
students-
calibration sessions, you will learn that lesson quickly.
I have.
But yeah, I mean, so any teaching of legal writing shouldn't necessarily invoke this, although I could see it as a vehicle to to perhaps I'm not sure we can have an absolute safe harbor in this kind of area, because it involves judgment. When you're inspected, somebody's going to look at the catalog, I suppose, and if they see a lack of electives and lots of bar review classes that smell like bar review, they're going to call it out, and you're going to have a conversation with them. And I can't speak about any future case, but at a minimum, you're going to have some time, I would believe, to correct that. It's not going to be a terminating event. So yeah, I don't know how I mean, a safe harbor, the best safe harbor is do as much as you want, but obviously I and perhaps other members of the committee object to that. I'm kind of at a loss here. But it just makes me nervous to read it. It seems to to open the door for unlimited bar review or bar prep, and it's only because the ABA is doing it that I kind of see that it would be unfair not to allow some amount of it, but because I've biased against it. I come from a world where this is something you did at your own expense after you graduated, right before the exam. Of course, I didn't have to take the first years, but and I worry about reducing the breadth of one's exposure to all the areas of the law in depth, as much depth as you can do when you spend a lot of time just preparing for the exam.
No, understood. But I think on the academic administrative side, we're concerned about the opposite occurring at the same time. If it's not defined well, how do we evidence it? And that way, even if it's, as an example, if we have an administrator coming to review the school and a program is labeled as legal writing, academic support, but as you look into the content, you say, no, that's a bar review. Okay, well, then we have facts for that. But if it's truly a legal writing analysis course, then it should not count in the number for bar review, because especially for our registered unaccredited, which I believe will be similar to our California accredited, these are first generation professionals. They have not had the polishing in their legal writing and their analysis and putting their thought process in this very objective format. They need more work in that area. And also for that same reason, many of them can't afford a commercial bar review outside after school. So I think many of the schools will create these internal programs to help them. Then it's part of the curriculum, and hopefully also increase the bar passage at the same time. Dean Park, I see you have your hand up.
Oh, yes. What I wanted to mention quickly here was, I think maybe the limit sentence even may have come from our group, but it just had to do again with, there are courses like a capstone one where they will go over legal analysis and exam practice, but again, it won't necessarily be a bar review. They're not trying to have students specifically prepare for the bar exam from that course. It's more of a analysis of educational learning outcomes at that point in that program. So that's part of why that limit is there. And the reason I don't think it will swallow the rule is really, it has to do with the last paragraph for me. And that had to do, yeah, I think so. I think that pretty broadly covers, these are the requirements that that must be met. I think it covers the different parts of our current regulations that should be applied in balance with holding a baby bar or CBX prep course. And it's actually my advice that if, there needs to be more clarified about balanced and comprehensive programming, that then that guideline is worked on. Because I think if you try to do it from this guideline, which just has to do with the restriction or the permission to do it, I think you're putting too much here when it may be better spread out or adjusted in the rest of the regulations that you have. And I don't foresee personally that someone would use this in a way that they can't meet 5.11 anymore, which, by the way, I just noticed it just says balanced and comprehensive. I don't know if that's the full title. I don't think that's the full title for that section. But, if there's going to be this setting of your program should look like this, beyond the practical training course credit, beyond the other core topics that you have, which is what the regulations already cover, we expect this, then I think that's relooking more at the balanced and comprehensive, I think, rather than this 1.11.
Mr. Chair, time check. We are now at 3:12. I'd like to touch base about a time check, and I don't know if we have our counsel Jean with us at this moment to determine how long we can go past the 3 o'clock notice time.
I'm trying to look at that now, Natalie. I don't have an answer. Usually we aren't running into this problem, so give me a minute and I can take a look.
Thank you very much.
And Mr.
Okay,
Johnson,
while you're doing that.
Yeah, while we have that minute, the committee member Kramer, could you screen share that component again? And then maybe. We
Oh,
can
yeah,
have-
because I
researches.
And just a side mention.
I typed something into it.
I know there's a external commercial provider language, I think, in the language that might be an update from what got posted in our minutes. But if that could be turned back to external test preparation course provider, I think that's always better than saying commercial provider, which is broad. So,
Mr. Chair, this is Dean Leal, I'm gonna have to log off, but if I could just make one last comment, I've made it before, I'll make it again on Friday to the committee when they consider this, is these guidelines work well, and they have worked well for decades, based on a good faith belief by the committee and staff that the deans of these schools regulated by these guidelines are doing their best to try to comport their school's curriculum to what's required. So I take a little offense to think that any school would look for ways to cut corners or make an end around this restriction. So with that, I'll trust that everybody will make the right decision, and we'll see what the committee does. So thanks for your time. Sorry I have to run, but I need to. So we'll see everyone later.
Okay. Understood and appreciated. And I believe we lost our committee member Kramer. So that might resolve our situation completely then.
Yes, and I will say that we do need quorum to conduct business. So if we've lost quorum, that does place us into a predicament.
Well, I thought Natalie said we only need 4 for quorum.
We do have 4. Because Mr. Murphy is still on, at least in picture. Perfect. So quorum is restored.
Oh, I hope okay.
Yeah, I was going to
pause there for a sec.
Yeah, what I did was shut off my VPN. While I'm doing that, let me also suggest, did Jean find that our putting a 3 p.m. end on the agenda limits our ability in any way?
I'm trying to locate that. I actually don't know that there is a specific provision about this. When we notice an item to take place at a specific time, we do have to abide by that. But I'm trying to look now. I don't actually think there is a provision, but I'm just trying to complete review of that while you guys are continuing on.
Yeah, and let me suggest then that unless it's really important for the group to end at a specific time, and that has been the habit, that we not put a specific ending time on future agendas to allow us to pour over a little bit if we need to.
So looking at our yellow highlighted portion, I see there's been some additions. So now the language is this limit does not restrict a law school from covering previously taught topics as part of a class whose primary purpose is to teach legal analysis or exam practice and other courses.
So we'd get rid of,
Yeah, I would personally be fine with that. I don't know if there's any other thoughts from our other committee members on that revised language.
I'm not sure if I follow how that change addresses some of the concerns. So let's say we're talking about a torts class for the first time, but we are trying to make sure our students are prepared for our own final exam in the class, a final exam that requires us to teach them how to do legal analysis because they're brand new and have no critical thinking skills or experience of the level that we're looking for. And so we're teaching them about legal analysis and how to write essay exams in ways that hopefully are also similar to what they see on the bar, because otherwise that would be very confusing. So I'm not sure how saying we can cover previously taught topics and teach them legal analysis helps address the concern that I think we were trying to address here. Right? The idea that we might have classes that are really doctrinal classes, but we're trying to be good teachers and have valid assessments. And so we're also teaching legal analysis and exam practice as part of that course.
oh, well, that's different from what I understood you wanted to do, which was to make sure if you're talking about using torts, for instance, as fodder for a legal writing class. So it's simply you need something to write about and it's going to be a legal issue. So to make it clear that that's not subject to the limit to, I'm unstable again. But anyway, I'm actually okay with this because I thought this was helping to describe your concern more precisely without being so broad that it worried me.
And my thought on it is I'm focusing on the primary purpose is to teach. ... The primary versus the primary purpose is for a bar review. So I see a distinction that if I was the administrator at the school dealing with a site visit, that I could say the primary purpose of this is not a bar review. Here's my evidence of it.
Yeah, you shouldn't have a lot of topic outlines, I would think, for one.
Yeah. So I don't know if there's any other thoughts, questions from our group on that highlighted yellow sentence.
By the way,
Oh.
somebody needs to tell George that this is not going to be on Friday's agenda.
I will follow up to reinforce that message. Thank you.
I want to respect everyone's time as well. I think how we drafted it originally was clearer. I have trouble understanding this. And I think the original way we drafted it, it covered more, it's okay for, introductory legal analysis or introductory exam practice to be covered in a class, not even all of its units, and it's not going to trigger turning this class into a test preparation course. So that's why I thought that that original way we wrote it addressed that kind of concern. And then beyond the capstone course for those law schools who have that.
Dean Keller?
Maybe revising the language differently might address the concern that I think I'm hearing Mr. Kramer saying. So we originally had this limit does not restrict a law school from covering legal analysis or exam practice in other courses. If we said something like the following, this limit does not restrict a law school from covering legal analysis or exam practice and other courses whose primary purpose is not test preparation. To that, maybe that draws that distinction of saying, you know, you can still do things that might overlap with different types of courses, and that's okay. We're not trying to say you can never do anything to teach legal analysis in other classes. We're just trying to limit a pure bar prep class. I don't know if that helps or not.
I think it helped me to understand the sentence better.
Okay, what was the last part?
From covering legal analysis or exam practice in a course whose primary purpose is not test preparation. Although now that I say test preparation, we might need to qualify that, because lots of things that we do in our classes is test preparation. So I suppose we would want to use the first year law school examinations and California bar examination test preparation.
I wanted to just weigh in quickly that you are welcome to continue. There's nothing that will prohibit us from continuing as long as you guys would like to continue engaging in discussion on this. So I just wanted to confirm that for you.
Thanks.
So it is legal so long as we're willing.
And just to make a point, the sentence and where we've placed it, is there any special reason it's located here versus the definitional paragraph? Would it make sense to move this up to the definitional paragraph rather than where it's currently placed?
Well, it does refer to the 15% limit, so it would be it
Okay.
would come before it, and that would be a little awkward.
Oh, so it's part of the 15% language, not the, oh yeah, it
Well,
is. I
That's
think
how,
it is.
how do we
now.
quantify it, right? How are we quantifying it?
Thank you for that. Yeah, I think because the back brackets are missing, I forgot that this is part of the 15%. Thank you. So it is appropriately placed.
So I prefer the second language from Dean Keller. I don't know if there's any other thoughts from other committee members on that proposed language. Dean Clancy?
I prefer Dean Keller's wording. I raised my hand originally to agree with Dean Park that I like the wording that was originally in place as compared to everything else that's been suggested. But afterwards, Dean Keller proposed the sentence that we're looking at now, and I like it the most.
So committee member Kramer, would you find that language acceptable?
Yes, I think so.
Dean Park, I see your hand is still up.
Oh, sorry, I should have lowered it, but I did have one last thing.
Please.
Maybe whose is, I think that's for a person. So in a course that has a primary purpose that is not test preparation, and I'm sure wordsmithing can come up with a shorter one, but I just think the whose might be for a person rather than a course.
Yeah, I'm drawing a blank, and
It probably is technically, but I can't think of any other way to succinctly make the same point, but we could.
Or maybe instead of who's that has
Me either.
that has a primary purpose. No, that
Of
might miss
course,
it.
having
that has its
having
primary purpose.
Having. Yeah.
Having a primary purpose, that is not.
Exactly.
That's-
Thank you.
Evidence that the hive mind is the best one. None of us separately could come up with that. Dean Clancy.
All right, do you wish me to go into the suggestions that I had mentioned a
Well,
little while ago or something else?
Well, if we could just finish this one, do we have any objections to it as it appears currently?
I like it the way it is now.
So then the one I'd like us, if we could fall back to, is just the definitional one. Because on the definitional one, I don't think we ever reached a consensus on the first one, the definitional one.
If
And
I may just touch on one last one, I'm sorry, I know for time, that edit in the last paragraph where it says provider. I just suggest it's external commercial test preparation course provider rather than only external commercial provider. But I'm happy if people think differently, but. Thank you.
yeah, no way, that's consistent language, which is always preferred. Absolutely. So if we could go back to our definition, because I think we have, and Committee Member Kramer, I think those were the areas that you identified. I don't know if there's any that I missed. Those are the ones I wrote down while we're having our conversation of the definition.
Okay, this part here, I think it's just clearing up the language, but you didn't specifically mention it.
So on my side, that's just clearing up language. I don't see the change. Is there any discussion from our committee members on the red underscored highlighted language currently in gray?
Just question, is it courses possessive or courses plural? And same with law school.
Well, it's one law school, so
I think the test preparation course apostrophe S, maybe that was originally like a paragraph around the S in case there is plural.
You mean parentheses?
Yes,
okay.
I think it may have been that in an earlier draft and not the apostrophe.
So if we're just, as Mr. Kramer said, we're talking about one law school, right? Any ownership interest of the law school in the test preparation course or courses provided by the law school, comma, its owners. Or is it supposed to be provided by the law schools? Possessive, it's law schools, owners, then.
Yeah, I missed
Yeah.
one deletion.
I think that reads clearly to me. And
Dean
I
Clance?
think the or makes sense rather than and.
Sorry, I meant to put my hand down. I'm standing by only to make comments about the couple things that I have in mind, but I like the wording that's been changed.
Good. So any objection to the current language of that? I don't believe so, but just in case. No? Okay. So now back to our definition.
So
Our
just a
definition
time check,
there.
Mr. Chair, we may, even if we do not lose quorum, we may lose staff support at some point based on prior commitments. So we do need to be mindful of the time.
I think this one hopefully will be a quick one to see if are we even in range of having a consensus as to the definition. So any dialogue on that from our committee members? Or is that a bridge too far on the definition?
I think you probably have enough votes to.
Well, no, is it a bridge too far to have consensus among everyone is the preference versus enough votes to make a recommendation? And we might have lost our connection again.
I apologize too, 'cause my connection's unstable, so I might be going in and out.
So quick question, any potential wordsmithing that might reach a true consensus, not a majority, but a true consensus in the definition? Not hearing anything.
I just wanted to state quickly, I do think that the group drafted definition is just a little bit more specific, and I'm more comfortable with if you're going to define what test preparation courses are, and this is only place it's being done in the guideline, that we do that very specifically and keep the first year law students examination and California bar examination modifier in with it. So that being said, I think most people would try to understand the term properly. So I think we're closer. We're close. It might just be a matter of, do we think the parentheses of the group draft, the standardized time closed book examination portion really needs to be there or not?
Well, as a proposal, Committee Member Kramer, would you accept a parenthetical being moved to the end of your definition?
Let's just put it there and take a look. Ignore the different font size.
I think
Yeah,
that would be clear enough. Oh, go ahead.
I'd be okay with that.
Any objection from our committee members at the new proposed version inclusive of the parenthetical?
I would support it. I think it's fair enough that those exams refers to the bar exams.
Dean Keller?
I'm okay with the 1-2 language. I actually didn't notice what Dean Park was pointing out, and what she just said she was okay without the reference to the first year law students exam and California bar exam test before test preparation courses. Now that she's pointed out, I think that's critical, because otherwise this guideline
not MPRE
refers to test preparation. Is that test preparation at the end of the semester in your class? Is it MPRE? Is it bar exam? So I wasn't focused on, I didn't think Mr. Kramer was really trying to take that piece out, was really looking more at the substantive. But I do think it would be important to start with the first year law school students examination and California bar examination, and then go into the redlined test preparation from there.
Excellent. Dean Clancy, any objection to the new proposed language, the red highlighted section?
No, the alternative formulation is something I agree to.
So it sounds like we have consensus then, just to make sure we're all on the same page, consensus on the proposed draft version in total. I know that Dean Clancy has a couple other areas he wanted us to focus on, but I think now, Committee Member Kramer, did we address the areas that you were concerned with?
Yes, thank you.
So with that, Dean Clancy, just in the interest of time, do you want to point out the areas you'd like us to focus on, and we can see, do we have time to do that?
Yes, well, there's not much left. Most of what I had in mind has been obviated by the changes we've already made. A few small things right at the top. California bar examination. This is going to sound trite, but I think we need to capitalize the B on bar, capitalize the E on examination. For stylistic purposes, we've got the first year law students examination, each word capitalized. So I think
that's going away though, right?
Say that again?
Actually, to be under the Chicago style, it may be lowercase, and I will double check that, Dean Clancy, as to what is appropriate with other
Okay, all right. Now, Mr. Kramer said
I'll
that's going
verify.
away, but I thought that
This goes away in favor of the alternate.
Except that
I
I
thought-
think before test preparation, just copy first year law students examination in California bar examination. Like just that to qualify what test we're talking about.
Well, but isn't it qualified here by this reference?
I think I agree with Dean Keller, and sorry to contradict what I said, but someone will say, oh, doesn't this define all of what test preparation courses are? Why isn't MPRE or something else also addressed within this guideline? it sounds a little ridiculous, but I think it's worth the redundancy ahead of test preparation courses. That is what 1.11 is talking about. And it's properly narrowed down from the front if we do that.
So if those words are in the title to the guideline, is that, does that serve your purpose?
That's true. I mean, I think people can read in, but I think it looks better with that in there.
Okay. It's
just a redundancy,
of course,
but it's
yeah.
a helpful one.
Okay, it is of course not a term we use anywhere later in this guideline.
Yes. Yeah, we don't want people to cross relate. And there can be future guidelines that use similar language. So I had one last thing, and I'm going to try to make it my last comment. Instead of with, maybe and would make sense here, because it does say contain both of the following. So before the number 2, if that with can be changed to and, I hope that doesn't really change anything, and it makes it easier to read. Thank you.
All right, Ned, I have
Clancy?
one other thing, and that is reversing the order of the last 2 paragraphs. The second to the last paragraph is about disclosure related to ownership, and it doesn't tie in as much to the prior paragraph as the one below it does. So I think the one below, meaning the last paragraph, needs to be moved up. Those 2 paragraphs, in my view, need to be inverted.
Yeah, and I had originally highlighted that. I didn't think it was important enough to raise in my priorities, but
Right.
but I certainly had the same sense as you have. So this one here would move above the one above it. Let's see if I can show you enough of it. Yeah. And it actually is logically, because you first say here you can use a commercial provider, and then the paragraph above is a limitation on, or a requirement of behaviors you have to engage in if you do so.
Any objection from our committee members to moving that paragraph?
No objection.
So I think we have a consensus version now. The only other proposed change I would make, committee member Kramer, if you could scroll up to your edited version where it had that language, if we could just delete that phrasing.
I mean, this.
Exactly, just that
Yeah.
colon, yeah. Because then I think it'll be
I
a
see.
pretty version.
Yeah, okay. Hopefully somebody would catch that in the edit.
This is the way I think of the world.
No, it's good to catch things when you see them, because we have so many thoughts running around in our little brains.
So Dean Clancy, did that capture all of your thoughts?
Yes, it does. Thank you.
So with that, then, is it possible to entertain a motion to adopt this version? Dean Keller?
I'm sorry, could you scroll down? I just wanted to see, I know we've moved so much stuff around, whether the brackets, we now have closed brackets there. Yes, okay, great. Sorry, just couldn't remember where we had moved that.
Better safe than sorry. Yes, thank you. Dean Park?
Make a note.
I'm close to, oh, sorry, I don't mean to interrupt. I'm close to making a motion. My last thing, and it's nitpicky, as long as the editor can catch that whatever is next to the rules needs to be the full title of what that rule section is referring to. Like balanced and comprehensive is an example of it, that might be incomplete. I am otherwise ready.
So you want to include that phrase in the title, right? The first year law school exam prep. Is that what you're saying?
Oh, no, actually, just in that paragraph that cited all those rules, I wasn't sure if the titles to those were complete. And I'm sure an editor can go through and check that. But other than that, I would be ready to.
So all these.
Motion. Yes. And I.
Okay, got it.
Maybe
That's
just
Natalie
a note.
work.
Yeah.
Yes, we will have an editor check those. Thank you, Dean Park.
Thank you.
So if we would like to entertain a motion then.
I would be happy to move that this would be the proposed version from CSBARS for CBE, making sure to include that footnote.
I'll second that motion.
So with that, Mr. Wool, could we poll or vote, please?
Okay. Jay Frickberg,
Aye.
Paul Kramer,
Yes.
Michael Clancy,
Aye.
Linda Keller,
Aye.
Greg Murphy, Jessica Park,
Aye.
and George Leal. I think the motion passes.
Now, with that said, Ms. Leonard, is there anything else we need to resolve? As we're 42 minutes over, with my sincere apologies.
Thank you. Just to confirm, we can put forward to another meeting the discussion on custodian of records at schools, and also a reminder to the members here and those in the audience or watching the tape that we welcome the submission of topic ideas for both the Law School Assembly taking place on September 29 and the registrar's meeting taking place on September 20. We would greatly appreciate the submission of those items no later than 1 week from Friday at the latest. You may ask about general or very specific topics. This morning, there was a discussion at the Law School Council in which a number of topics that I think will be of general interest were identified, but we welcome additional submissions.
Thank you. And with that said, unless there's any objection from our group, I believe this will complete our committee meeting today. Thank you, everyone.
Thank you,
And we'll-
everyone.
Take care.
Thanks.
So